Bart's versus Anthropic, which was a pretty big case that I think illuminated how US law sees a lot of this stuff. I know a lot of publications often will say something like these AI models are trained on copyrighted data. Of course, they're going to use books and textbooks, and of course, books and textbooks are copyrighted. So when people say, these AI models are trained on copyrighted data, that implies that these AI models are breaking the copyright law somehow. I think a lot of people kind of take it to mean that, but that's really not correct. It's more about fair use. That's my understanding. So maybe you can just kind of enlighten us about what those words mean or don't mean and kind of like how we should be looking at it.
Yeah. It's true that AI models are generally trained on copyrighted data, but that could be done lawfully or unlawfully depending on the circumstances. So many AI models choose to use copyrighted data like books and artwork in order to train their models because copyrighted data often is exactly the kind of creative expression that is useful for generating outputs that are going to exhibit some amount of intrigue or interest. It's going to be much better writing when you can train it on high quality underlying works. And so books are a prime target for that initial training. And as we saw in many of the lawsuits, most of these AI companies did use books as the center of their initial training for these AI models. Now, as we'll get into when we discuss the cases in more detail, some of those AI companies obtained copyrighted works lawfully. So, for example, by purchasing copies, and many of them obtained copyrighted works unlawfully, such as by downloading them from torrent websites. And there are differences of opinions among the cases that have come out so far as to whether engaging in training using copyrighted content that wasn't lawfully obtained is in fact unlawful or not when you're using it for AI training. Some courts say that that initial fruit of the poisonous tree is problematic, and some courts say that once you are using that for the purpose of AI training, if that AI training is a fair use and doesn't infringe copyright or it's a defense to copyright infringement, then that underlying use of pirated material is likewise not unlawful. I think that we'll see courts continue to be divided on that topic. It's a hotly contested issue.
Oh, I bet. And how should people be thinking about fair use? So my understanding there's like 4 different sort of checks to understand if something is fair use or not. And that's like a lot of what the lawsuit went into. Can you help us understand that a little bit?
Yeah, there's 4 factors that go into the copyright fair use analysis. So once you've determined that something is an infringement of copyright, meaning does it reproduce something that is copyrighted, or does it create a derivative from something that's copyrighted, or did it use that work for the purpose of creating an additional work? So usually copies are made in that process. So for most AI models, they maintain a library of their initial training materials. And so that's the initial copying that would constitute copyright infringement. And then the person who's being sued for copyright infringement can come back and raise fair use as a defense. Fair use is designed for circumstances where the use of the copyrighted works don't harm the copyright holder as much as the public benefits. And there's a statute that sets out 4 factors for determining whether something constitutes fair use. One of the first factors is the purpose and character of the use. And a big question there is this a commercial use or a nonprofit or educational use? Commercial uses are less likely to constitute fair use. But again, all of these are factors and not be-all, end-all. Another consideration for that first factor of the purpose and character of the use is whether it's transformative. So this is the thing that comes up a lot in these AI training cases. Courts have said that because AI models are fundamentally and in extreme ways different from the original purpose of reading a book, for example, training an AI model or even creating outputs from an AI system, fundamentally give you a different experience and have a different purpose. And so courts say that's transformative. And when you have this transformative use, that initial factor favors a finding of fair use and therefore a defense to copyright infringement. There are a few other factors that are also important. So, for example, whether the nature of the work that's being infringed is one, although this one almost always weighs against a finding of fair use. This is something like, is the work that's being infringed a novel or something creative? Or is it something that's really on the cusp, like a phone book, or something that doesn't have a strong entitlement to copyright protections, that isn't strongly expressive? For almost all works that are being sued over, this is a factor that weighs against fair use because most works that are being sued over are creative works that are clearly entitled to extensive copyright protection, like a novel. Then you have the amount and substantiality of the use. What this means is how much of the copyrighted work is being used in the infringement. So the classic example might be if you have a YouTube channel and you're taking a clip from some other YouTube channel and you take 30 seconds of another person's YouTube clip in order to educate your audience on what that clip was about for the purpose of you being able to talk about it. That's a very small amount of a clip to use, and it's central to your purpose of commenting on and criticizing or whatever it is that you're doing with the original clip. So that amount and substantiality will favor fair use if you take only as much of that original as is necessary to perform what it is that you're trying to do. So if you're making commentary in a clip and you only use 30 seconds or a few seconds of the clip, that's probably fine as fair use goes. Although all of this is on a case-by-case basis, and a small amount of use can still be substantial if the clip was only a few seconds. In the context of AI, this amount and substantiality question is really difficult because oftentimes the AI ingests the entirety of the work. So this would be like taking in the entire hour-long YouTube video, right?
Right.
Or it takes in the entire novel. And if you're doing that, you'd think, well, this is a factor that probably should weigh against fair use because we're using the entirety of the copyrighted work. But the cases that have come out so far, and we'll see if other cases differ when new ones come out, but the cases that have come out so far have said that because AI models must be trained on millions and millions of works, and it's necessary to have the full work for context, that in those situations, the amount and substantiality of the use factor favors fair use, even though you use the entire novel. So they're looking more at how it's being used, that it's necessary to look at the entirety of the book and include millions and millions of books in order to make an AI model. And then the last factor is one that courts differ on how important it is. We'll get into this when we talk about the cases, but the Meta case, for example, the court said that this factor on the impact of the infringement on the marketplace for the original work, that this factor is critically important. And that Meta case found that most AI training is going to not be fair use because it results in flooding the marketplace with AI-generated works that are going to compete with the originals. And so the Meta case said that in every other case except the one that they decided, because they ultimately found in favor of Meta, they said in almost every other case, we would likely see an impact on the market effect. And so in that case, it won't be fair use. That's a bit of a stretch, this idea. It's called a market delusion theory, this idea that new works are going to come in and outcompete the original works, even though they're not the same. Traditionally, this factor considered whether the infringement is going to result in direct competition for the exact same work. And it's very different to look at it from a perspective of completely different works competing in the same marketplace.
Yeah. So where would that be? Where would that happen other than these large language models? Is there an example of, so I can kind of get my head around this?
It's a brand new theory. So
Okay.
this Meta case is one of the first cases where a court has articulated this market delusion theory of the factor for market analysis for fair use. Because it's a brand new theory, that was part of the reason why it was very difficult for the plaintiffs in the Meta case to establish that that factor favored them, because the plaintiffs had no idea that the court was even going to use that market delusion theory until it got the opinion back. So without looking at the court's opinion saying that this market delusion was an important theory, the plaintiffs just didn't enter in any evidence of that. They could have had an expert testify to that, but they didn't do so. And so it's a bit of a chicken and the egg problem. Without knowing that that theory was in play, it's very difficult to present evidence in support of that theory.
Yeah, and we're still arguing over things like the invisible hand, so it feels like that'll be a really tough one. I'm sort of curious, like, how does what you're seeing play out with large language models versus the same situations if they were done by humans? So if there was a person, for example, that broke into someone else's house and I guess read a creative work that they didn't own and then went out and made a blog about what happened, and they were, definitely breaking the law when they broke into the house to learn it, would that rights be owned by the original people that they learned from? Or because it's a human brain, does it become more free to what came out of it?
That's a great question. And with the case law around human actions, we have a lot more established precedent than we do, obviously, in the case of AI training. So in the case of the human who breaks into a library, reads some information, and then comes out and makes a piece of artwork that's infringing, there's a few steps along the way that would potentially be unlawful. So number one, you would have that action for breaking into the house. Now, reading somebody's book is not unlawful. So just picking up a book and reading it, not unlawful if you have lawful access to it, but breaking into the house is going to be a violation of law. Similarly, if you were to download a pirated library and read it, that action of downloading the pirated material would be unlawful because you're creating a copy of a copyrighted work without authorization from the original copyright holder, which is one of the types of actions that constitutes an infringement of copyright law. Next, the question would be, what are you doing with the material? So under the theory of the Meta case, where they take this approach with pirated material, saying that if you use pirated material, it's no problem as long as the end use that you're using it for is fair use, if you're using it for training. So likewise, you could think that if that were applied to a human who downloads pirated material and then uses it for a purpose of fair use, like creating an entirely new work that's not similar to the other works that they read, then that's not going to be a violation of copyright law under the meta-analysis, under the Kadri versus Meta case. But that's a very different theory. That's very different from what we've seen for human uses. For humans, generally, if you download pirated content, you download pirated content, and that's unlawful, right? But then let's get to the next question, the separate violation. And this is how the Bartz versus Anthropic case treats it, as separate violations. The pirating is one problem that we need to address, and the Bartz versus Anthropic case says pirating is unlawful. You have to pay for that. And then we have a second potential cause of action for what you do with it. And with a human, if you, let's say, instead of breaking and entering or downloading pirated content, you went to the library and you spent a year reading everything in the library, and then you create some new work. What the court would do is first ask, is there a copyright infringement? If you make something that is substantially similar to or identical to something that you've read, that is a copyright infringement. And the court has a bunch of factors and considerations for whether something is going to be substantially similar. You may have experts come and say how similar things are. This is where you see in music cases where you've got some expert analyzing each note to see how similar they are. And if it's substantially similar, it's going to be an infringement if you go out and publish or sell whatever it is that you're making. That's going to be an infringement, and it probably doesn't constitute fair use because you're creating something that is often commercial in nature or generates some benefit for you that isn't really a public benefit. You're not creating the work for the purposes of criticism or commentary on the original underlying work. In that situation, you're not going to get the benefit of the fair use defense. And the court's just going to say, look, you made something substantially similar to something you read. The end, that's copyright infringement. When it comes to AI, courts are finding differently. We see in the Bartz versus Anthropic case that the court says it's fundamentally transformative to create an AI system. And so the court's saying that that's somehow different from what a human is doing. And it was important in that case, though, that nobody alleged that what was being output by the AI was substantially similar to any input. And in fact, they had guardrails in place in order to prevent the outputs from being the same as or substantially similar to the inputs that went into the system. This was critical for avoiding that problem of that you might see with a human that comes out and makes something similar.
So you said that the courts basically said that what AI models are doing are different from what humans are doing. Can you explain that a little bit?
Yeah, so the courts are saying that the AI models are transforming the original purpose of the work. Instead of just reading a book to make a book that's similar to the previous book, AI models are reading many books to create a system that fundamentally transforms our lives and does something different than a single book does. So they're saying this is very different. Go ahead.
Isn't that kind of like what humans do? I mean, you go to school, you read a bunch of books, and then you're able to produce your own kind of novel content. That's not what they mean, though, because so they're saying it is.
Yeah.
Yeah, just
So
to
in
build
that
on that,
sense- Go ahead.
there's also a human has the choice to make something that's a really close direct copy or something that's extremely different and only has a hint of the original work. There's a whole range. And in this case, we're talking about an LLM that can be prompted in ways to do one or the other. So it's not like in all cases, it's going to be copyright like looking, but sometimes it might be very similar to what it digested. If the user prompts it, like, hey, give me a very close approximation of this book, then it's going to look a lot closer.
And fundamentally, you're right. If you were to take the example of a human who is not making anything substantially similar to what they read, that's not going to be viewed as a copyright infringement. We wouldn't even need to get to the fair use analysis because humans are not considered to be making a copy of the works when they read it. When you read a book, you don't download a copy into your brain. Right. And so you don't have that underlying act of infringement that the AIs are engaged in, right? There's some debate over whether AIs actually do make a copy, but in these cases, there are situations where there was a library where they admitted that there were copies of the underlying training data. So humans don't make a copy of what they read in their brain unless you have a very good photographic memory. And even then, you probably won't get the whole book in your head, right? My mom had a side note. My mom had a photographic memory. And when she was in school, she once got in trouble for plagiarism because before she went into a closed book exam, she used her photographic memory to memorize the section of the book that was relevant to the exam and then wrote the answers verbatim from the book. From her memory, and the teacher said, "No, that's plagiarism. You can't do that." And she says, "I didn't copy it from the book.
Weird.
I copied it from my memory."
But in a weird way, even if she did get it from her brain, it still kind of feels like she cheated to me. Like I know she didn't look over at someone else's page, but the point is to synthesize the question and understand it in context. And she learned it. That's fascinating.
So that's the same thing that they're saying is happening for these AIs, that you're basically having a perfect copy that gets made in order to generate the final outputs. And these cases would be coming out very differently in situations where the plaintiff is alleging that the AI system is generating outputs that are verbatim from the inputs. So in the New York Times case, for example, against OpenAI, that's one of the allegations that is going to be very important for the outcome of that case.
Yeah, I read what they submitted as kind of proof of what was happening. There's something a little bit weird there. I made a video about it, and then later, actually, OpenAI came out and said that it's not what it seems. So it's going to be very interesting to see, because the thing is like how it's structured. The outputs are structured. There's like an introductory paragraph, the actual response, and then kind of a summary. And based on the summary, you can tell how the prompt was structured, and they removed all the last paragraphs. So I'm like, oh man, like that would have told us a lot about how they were able to get the model from, to output that result, which is interesting because Anthropic is saying that they put in guardrails that prevent specifically the outputs from being the same as whatever the inputs were for the training data, which is brilliant. I mean, it seems like, because that would definitely take care of that issue. But I want to just dig deep a little bit more into what it means to copy something. Because, for example, like you said, humans don't copy it; they read it, and then they're able to recall it. Whereas with the training of the models aren't copying the information, but in order to have the data to train the model, you do need to copy it on some server and then use
Mhm.
that to train the model. Do you know if Google, is that the defense they use? Because they crawl the entire web with their little crawl bots, and but they never copy the web pages. They sort of like just kind of like distill them to the number of links or whatever. So they kind of have a mathematical representation of the website, but they don't copy it. Is that what allows them to do that?
Yeah, there's a lot of debate, and that would be something that needs to come up in fact discovery in all of these cases. But most of the initial lawsuits are being brought against companies that have stated that they have some sort of library or that they made copies or downloaded copies of
Mm.
these books or the other data that they're using for training. Whereas there's other AI systems that are swearing up and down that they don't make copies of the material for purposes of ingesting into the AI, that they tokenize it first in order to then use it for purposes of training the AI.
That's exactly where I was wondering if there's a way to get that training data without copying it, because I don't think you need the exact copy. There's probably some way to, yeah, tokenize it, or I don't know, have like the crawl bots crawl the web, maybe like just never copying it to. So so I'd be curious to know, because there might be some simple shortcut around it. Um,
Although you'd think that even depending on how you're operating, even if you're crawling the web, wouldn't you make a copy when you have a cache or something like that? I mean, I think this is all really fact intensive. And there's going to be experts that talk about exactly how the technology works for those particular companies. But there's a reason why these initial lawsuits are against companies that have admitted to maintaining copies of their training materials.
Yeah. And what did you think about the fact that, so there's two big lawsuits, the one involving Meta and the one involving Anthropic. And both of them are using pirated books or whatever pirated material in order to train their models on, which is, of course, we understand that to be illegal, breaking copyright laws, et cetera, using torrented sites. In one case, in Anthropic's case, the judge says, well, that's wrong. And in Meta's case, the judge says, it's fine. Like, what's your take on that? How's that happen?
My personal take on it is that the judge in the Meta case has it completely wrong. It seems unreasonable to me to say, and other scholars disagree with me on this, but my perspective, it seems unreasonable to say that pirating or torrenting copyrighted works is fine as long as you have some intent to use it for some transformative purpose in the future. That, how could that be? Anybody can train AI models now. So if I decide to go torrent all the episodes of Star Trek and make myself a Star Trek AI,
Yeah, like
I like Star Trek, make
nonprofit.
myself a Star Trek answer AI, that all of a sudden my torrenting all of the Star Trek episodes is going to be deemed lawful because I decided to make myself a Star Trek ask a question AI. That seems completely wrongful in my mind.
It's got a
And
Robin Hood vibe to it, you know? Like you're
yeah,
like, well, I can steal it as long as I'm giving it away.
Right.
yes, very Robin Hood, right? Whereas the Bartz versus Anthropic case, I think, has it right in that if you lawfully obtain copies of the work by purchasing them, you can train an AI model to your heart's content as long as you're not creating additional copies that are going to be distributed to the public and you're using the copies that you make only for the purposes of training the AI. It's not going anywhere. It's not getting duplicated. And in those situations, I think that's fine. You can use that to train an AI. Now there's other questions about whether just the mere fact of training an AI on the work is going to constitute some kind of copyright infringement. But I think the wrong copyright doesn't quite fit the wrong there because
Mm.
you're not reproducing or creating derivatives of precisely that work necessarily. I think there's arguments to be made, but that one, probably the courts are going to land pretty clearly on the side that if you're not making any copies, that's probably not going to be copyright infringement. Or if you're not making derivative works, that's not going to be copyright infringement. But when it comes to pirated works, the Bartz versus Anthropic case said it doesn't matter if you're using those works to train an AI system, and if the training itself is fair use, we're also going to separately consider the act of pirating content. And if you're downloading things that you didn't purchase that are copyrighted, then you're liable for that. Now, interestingly, the Bartz versus Anthropic case is going to go to trial on damages for that pirating of material. And because many times books are not only copyrighted but also registered, they're entitled to enhanced damages. Registered copyrights are entitled to enhanced damages, statutory damages for infringements. And that's based on a per work number. It can rise up to $150,000 per work if the use is willful. And so we could be seeing potentially millions or billions of dollars of copyright statutory damages in that Bartz versus Anthropic case, depending upon the size of the class of authors and the number of works that are deemed to be infringed.
Yeah, and that was
Yeah.
one of my questions is like that seems like it might be an existential threat for Anthropic. Am I understanding that correctly?
Yeah, I think they'll probably be able to find some way to get out of it, whether through perhaps some sort of insurance claims or perhaps some sort of deal with authors. We may see something like a settlement that could provide some sort of compensation fund for authors to receive some amount of damages that would be less than the $150,000 per work. I think that if this ends up going to trial and the court finds that there are millions and millions of pirated works that were all copyrighted, that's a huge amount of damages. But also a lot of these AI companies are generating millions and billions of dollars of revenue, so it's not necessarily going to be the end for them. It's just going to be very difficult, and they're going to have to make sure to use lawfully obtained works in the future if this ends up being the law. Of course, all of these cases are going to be subject to appeal, and it's likely that a court's going to stay any award, meaning they're going to pause the application of whatever their ruling is, like whether that's damages awards or something like that they're probably going to stay those pending appeal, and that these kinds of cases are going to go all the way up to the Supreme Court. That might take 10 years, maybe 5 years if we're lucky. And so a lot can happen in 5 years with these AI companies. So I think also they may change their practices. They may start to find a way to obtain works lawfully. Hi, I'm Christa Laser, and I'm a professor of intellectual property law at Cleveland State University College of Law. I'm also the director of the Intellectual Property and Entrepreneurship Center, which is newly formed there. I have a YouTube channel and a website at christalaser.com where I post topics related to intellectual property law and innovation, including AI, blockchain, and biopharmaceuticals as well.